Welcome to today's program, USPTO Hour, Central Reexamination Unit. I'm Sean Hunter, the Director of the Office of Patents Stakeholder Experience here at the United States Patent and Trademark Office. Before we begin, just a few housekeeping reminders. If for any reason you should get disconnected, you can log out and then log back into today's program at any time by using the WebEx link provided and login information that brought you here. Additionally, if you are having issues with audio or audio connectivity, you can send a message directly to our digital media services team in the WebEx by selecting the panelist that starts with the letters DMS and sending a message directly to them. As a reminder, we will have a live Q&A segment during today's event following the presentation. Questions were taken in advance via email at usptohour@uspto.gov. That's usptohour@uspto.gov. Please feel free to use this email during today's event to submit questions, as well as if you have any questions for any other iterations of this event series. If you happen to miss a portion of the program today, don't worry. In a few weeks, we'll be posting the recorded presentation online. The USPTO recently unveiled 7 Patents Business Unit priorities, which are represented by the acronym INVENTS. Each priority represents the agency's commitment to strengthen the U.S. patent system, enable inventors to secure patent protection for their inventions, and provide durable patent rights that make the United States intellectual property system the best in the world. With that, it is my absolute pleasure to introduce Charles Kim, Deputy Commissioner for Patents, Fenn Mathew, Acting Director, Central Reexamination Unit, and Stephen Stein, Management Quality Assurance Specialist, Central Reexamination Unit. Charles Kim serves as the Deputy Commissioner for Patents of the United States Patent and Trademark Office. As Deputy Commissioner for Patents, Mr. Kim is an authority on patent laws, rules, and examining practice and procedure, and provides executive leadership to the Office of Petitions, the Office of Patent Legal Administration, the Office of Patent Quality Assurance, the Central Reexamination Unit, and the Manual of Patent Examining Procedure staff. Prior to becoming Deputy Commissioner, Mr. Kim served as Acting Assistant Commissioner for Patents, and prior to that, held the position of Director of the Office of Petitions. He has also served as Senior Advisor to the Deputy Commissioner for Patent Examination Policy and as a Supervisory Patent Examiner in Technology Center 2100. In addition, Mr. Kim has led the USPTO's Artificial Intelligence, or AI, and Emerging Technologies Working Group. In this capacity, Mr. Kim provided executive leadership to a cross-cutting team of AI specialists from across the agency that developed and implement various AI and intellectual property policy initiatives here at the USPTO. Mr. Kim earned his Bachelor of Science in Electrical Engineering with high honors from Rutgers University and his Juris Doctor from George Washington University Law School. Mr. Kim also holds an executive certificate in public policy from the Harvard Kennedy School. Ben Mathew currently serves as the acting director of the Central Reexamination Unit, or CRU. In this role, he provides executive leadership over CRU operations and policy. Mr. Mathew also currently serves as the director of the Office of Petitions, providing executive oversight on petitions, examination practice, and policy. Mr. Matthews started his career at the USPTO in 2001 as a patent examiner examining biomedical technologies. During his career, Mr. Matthew has served as a supervisory patent examiner trainer in the Office of Patent Training, where he was responsible for training newly hired patent examiners. As a supervisory patent examiner in Technology 3700, as well as the deputy director of the Office of Petitions. Mr. Mathew earned a Bachelor of Science in Biomedical Engineering and a Master of Science in Biotechnology from the Johns Hopkins University and a Juris Doctor from the George Mason University School of Law, now the Antonin Scalia Law School. Stephen Stein currently serves as the Managing Quality Assurance Specialist in the office's Central Reexamination Unit, or CRU. Mr. Stein joined the USPTO in 1998 as a patent examiner in the Chemical Technology Center, examining various inorganic materials. In 2005, he joined the CRU, first as a patent examiner, and in 2011 became a CRU supervisory patent examiner in 2011. He has held his current position as the CRU's managing quality assurance specialist since 2017, where he oversees both reexamination and reissue examination practice and their interplay with prior and pending AIA post-grant trial proceedings. Mr. Stein holds a Bachelor of Science degree in chemistry from American University in Washington, D.C., and received his JD from Widener School of Law. With that, it is my pleasure to turn it over to you, Charles, Fenn, and Stephen.
Great. Thank you, Sean, for that kind introduction. And good afternoon, everyone. And depending on where you are, good morning. As Sean mentioned, my name is Charles Kim, and I serve as the Deputy Commissioner for Patents here at the USPTO. And I'm joined by my colleagues, Fenn Mathew, Acting Director of the Central Reexamination Unit, or CRU, and Steve Stein, our Management Quality Assurance Specialist, or MQAS, also from the CRU. So today, Fenn, Steve, and I will be discussing the topics shown on this slide. I will kick things off by giving an overview of the CRU, including its history, as well as a discussion on the three types of proceedings that are handled by the CRU. Then I'll hand it off to Steve, who will go over some best practices. And Fenn will cover the last topic, which includes some re-exam statistics, as well as some recent updates. I don't want to steal too much of Fenn's thunder, but I'll note that we have seen a significant increase in re-exam filings over the past month and past few months, actually. And we are actively taking steps to address this increase in filings to help ensure that the CRU maintains high quality and timeliness. Fenn is going to discuss some of the great work that's being done by the CRU team. Next slide. All right, so I'll start with the brief history of the CRU. Re-exams have existed at the USPTO since the 1980s. And for many years, re-exams were handled in a decentralized way. That is, they were assigned to examiners across the Corps alongside their regular examination duties. And because relatively few re-exams were filed, many examiners did not encounter them on a regular basis. So when a re-exam was assigned to an examiner, examiners often needed to learn or relearn the relevant statutes, rules, and procedures. And that learning curve contributed to longer re-exam pendency, and it also raised concerns about consistency and quality. So the CRU was established in 2005 with a clear goal in mind, and that was to improve quality and timeliness of re-exam proceedings by centralizing the processing of re-exams within a select group of primary and supervisory patent examiners. This centralization was intended to concentrate experience and knowledge so that the office could apply the re-examination laws, rules, and procedures more consistently and efficiently. And as a result, we were able to reduce our pendency and improve our quality. Then in 2011, the Leahy-Smith America Invents Act, or the AIA, was enacted into law. The AIA impacted the CRU in several different ways, and I'll briefly mention a couple. One, it replaced inter-parties re-exams, which up until that point were handled by the CRU, with inter-parties review, or IPR, which, as you may know, are conducted at the Patent Trial and Appeal Board, or the PTAB. And the PTAB was also established by the AIA. Previously, it was known as the Board of Patent Appeals and Interferences. The AIA also established a new post-grant proceeding called supplemental examination. And in 2012, CRU began reviewing requests for supplemental examination. A couple of years later, in 2014, CRU also began examining reissue applications, which were previously examined in the Corps. Next slide. All right, so in the next few slides, I'll give a high-level overview of the three types of proceedings that are handled by the CRU. And as I discussed in the previous slide, and as shown on this slide, these proceedings include ex parte reexaminations or reexams, supplemental examinations, and reissues. And while the CRU handles most of these three types of proceedings, I do want to mention that requests for these proceedings that relate to design patents are not processed in the CRU, but instead are handled by the Design Technology Center, or TC 2900. Next slide. So this chart shows some of the similarities and differences between the three types of proceedings in terms of who may file a request, the scope of the proceeding, the types of amendments that can be made, and the outcome or result of each proceeding. So who can file each type of proceeding? For re-exams, the patent owner and any third party that is not subject to the statutory estoppel provisions, which I'll discuss in more detail, may file a re-exam request. For supplemental examination and reissues, only the patent owner may file a request for those two proceedings. With respect to the scope of each proceeding, re-exams are limited to patentability issues that are based on prior art patents and printed publications, that is, issues generally relating to anticipation under 102 and obviousness under 103. Supplemental examination and reissues, however, are not limited to patents and printed publications and can involve all patentability issues, including, for example, 101 and 112 issues. With regards to the types of amendments that can be made, for re-exams and supplemental examinations, broadening amendments, that is, amendments that broaden the scope of a claim, are not permitted. In reissues, however, broadening amendments may be permitted if certain requirements are met, such as if the reissue was filed within 2 years from the patent issuance. In terms of results, when a re-exam concludes, we issue what we call a re-examination certificate. For supplemental examinations, we issue a supplemental examination certificate, and if re-exam is ordered as a result of supplemental examination, we would also issue a re-exam certificate. And lastly, for reissues, if any claims are found to be patentable, then we would issue what we call a reissued patent. Next slide. All right, so the next few slides relate to ex parte reexamination. Ex parte reexamination is a type of post-grant review that enables the office to reassess an issued patent when there is a substantial new question of patentability, or SNQ, that is based on patents or printed publications. So what exactly is an SNQ? The MPEP explains that an SNQ is raised when there is a substantial likelihood that a reasonable examiner would consider the patent or printed publication to be important in deciding whether or not the claim is patentable. And as I mentioned earlier, anyone, including the patent owner or a third party, may file a re-exam request. And the request must be filed during the period of enforceability of the patent. This period of enforceability is generally the length of the term of the patent, plus the 6-year statute of limitations period for bringing an infringement action. And although a re-exam request can be filed by anyone, there are some key differences between requests that are filed by the patent owner versus a third-party request. For a third-party request, which is much more common, the request must include a certification that the copy of the request has been served on the patent owner. In addition, the request must also include a certification that the statutory estoppel provisions do not prohibit the requester from filing the re-exam request. The statutory estoppel provisions apply when at least one claim of the patent for which re-exam is being requested was previously challenged in an IPR and/or a PGR proceeding that resulted in a final written decision by the PTAB. And as another preview, I'll note that earlier this month, we issued a notice that relates to these statutory estoppel provisions, and Fenn will discuss that notice in more detail. Lastly, I'll just briefly mention that re-exams can also be initiated by the director in what we call a DOR, or a director-ordered re-exam. DORs tend to be rare, but we did recently issue a DOR this past November. Next slide. All right, so once a re-exam request is properly filed, the office will determine whether an SNQ affecting any claim of the patent is raised by the request. And if an SNQ is found, the office will issue an order for reexamination, and reexamination will proceed. However, if no SNQ is found, then the request for reexam will be denied. The statute requires that the SNQ be determined within 3 months from the date that the request is filed. As I mentioned earlier, most re-exam requests are filed by third parties, and when re-exam is ordered in response to a third-party request, the patent owner may file a statement within 2 months from the mailing date of the order. The patent owner statement can include proposed amendments that can narrow the claims. If the patent owner files a statement, the third party may file a reply. However, if the patent owner waives the right to file a statement or decides not to file a statement, the third party is not permitted to file a reply. And from that point on, the third party is no longer permitted to file any further papers in the proceeding, although they will be sent copies of the office actions as well as the patent owner responses. So as you can see, even though a third party can request a re-exam, their participation in the re-exam proceeding is limited due to the ex parte nature of re-exams. Next slide. All right, so once we conclude the re-examination process, the office will issue what we call a NERC, or a Notice of Intent to issue a re-examination certificate. And this is similar to a Notice of Allowance in 111A non-provisional applications. The re-examination certificate will include any patent claims that have been canceled, any original claims that were confirmed to be patentable, any amended or new claims found to be patentable, any claims that were disclaimed, and any claims that were not subject to re-examination. It can also include any terminal disclaimers that may have been filed during the re-exam proceeding. So once the re-examination certificate is issued, it becomes part of the issued patent for which re-examination was requested. And that's similar to a certificate of correction that may be issued in the patent. So before we move on to the next slide, I'll just briefly mention that there is a flow chart in the appendix section of the slides, and this flow chart illustrates each of the steps involved in the re-examination process. So if you're interested in learning more about the re-examination process, I encourage you to take a look at that flow chart. Again, it's in the appendix, as well as MPEP 2200, which provides information about re-exams. Next slide. All right, next, moving on to supplemental examinations. Supplemental examinations provide a mechanism for the patent owner to request that the office consider, reconsider, or correct information believed to be relevant to the patent at any time during the enforceability of the patent. Unlike re-exams, however, supplemental examinations are not limited to patents or printed publications, and instead can include any information that the patent owner believes to be relevant to the patent. For example, the information may include not only a patent or a journal article, but it can also include a sales invoice or a transcript of an audio or video recording. One of the benefits of filing a supplemental examination is that it could help to preempt potential future allegations of inequitable conduct that could arise during patent litigation. And after a supplemental examination request is filed, within 3 months, the office will conclude the supplemental examination and issue a supplemental examination certificate that indicates whether the information in the request raises an SNQ. And as I mentioned earlier, if re-exam is ordered based on a request for supplemental examination, the scope of the re-exam proceeding is not limited to patents and printed publications, but instead it includes all patentability issues, including 101 and 112 issues. Next slide. All right, so moving on to reissues. Reissue applications allow patent owners to correct certain errors that were made in the original patent, where as a result of the error, the patent is deemed wholly or partly inoperative or invalid. The requirements for reissue applications are a little different from, for example, a 111A non-provisional application. For example, reissue applications require an oath or declaration that is specific for reissues. The reissue oath or declaration must contain certain statements, including a statement of at least one error which is relied upon to support the reissue application. Also, there are some differences in formatting requirements as well. For example, the specification for a reissue application must be submitted in the form of a copy of the printed patent, which is in double column format. And this is different from the single column format that's used for specifications in 111A applications. A reissue application must also include the written consent of all assignees, if any, that currently own an undivided interest in the patent. And these assignees must also establish their ownership in the patent by filing what we call a 373 statement. Next slide. So this slide shows the most common reasons for filing a reissue application, and they include claims that may be too narrow or too broad, inaccuracies in the disclosure, correction of inventorship issues, failing to claim or incorrectly claiming domestic benefit or foreign priority, and failing to make reference to or incorrectly making reference to prior co-pending applications. Unlike re-exams and supplemental examinations, amendments can be made to broaden claims in reissue applications. However, this can only be done if the reissue application was filed within 2 years of issuance of the original patent, and only if the broadening amendments do not attempt to recapture subject matter that was surrendered during prosecution of the original patent application. So that concludes my high-level overview of re-exams, supplemental examinations, and reissues. Next, I'll turn it over to Steve, who will go over some best practices for these 3 types of proceedings. Steve?
Thank you, Charles. Again, my name is Stein, and I am the Management Quality Assurance Specialist for the Central Reexamination Unit. Can we go to the next slide, please? So I'm going to break this up into several different parts, and I wanted to start off with best practices related to ex parte reexamination. These topics were chosen based on issues we've seen in the CRU where parties have filed requests for reexamination, reissue applications, or presented papers during the prosecution of those proceedings, which didn't quite comply with the rules and regulations. Starting off with ex parte reexamination, I wanted to talk first about streamlined ex parte reexamination as an option. Next slide, please. In 2017, the office issued a rule that included streamlined ex parte reexamination. Streamlined ex parte reexamination provided filers of reexaminations requests with a 50% reduction in filing fee if certain requirements were made. The requirements are that the streamlined request must have 40 pages or less and must comply with other requirements under the reg. Those other requirements include that the request be limited to 12-point font in Times Roman, and also be limited to 1.5 or double spacing. An important thing to remember for the page count for streamlined reexam is that claim charts, even if separately presented from the arguments in the request, are included in the page count. In addition, any third-party declarations which contain arguments as to patentability are deemed to be included in that 40-page count. So if the third-party requester presents declarations which go outside of merely providing evidence as to the contents of the prior art presented in the reexam request and includes arguments directed to patentability, those pages are included. If the request is determined to be contain more than 40 pages, then it will not comply with the rule, and the requester would be charged the 120 C2 or regular fee. One more thing I wanted to mention regarding this is that the current PTO SB 57 reexam transmittal sheet provides the opportunity for the requester to include a deposit account separate from payment of the fees for any required additional fees. Moving on to what needs to be in the request, as Charles indicated, to establish a substantial new question of patentability, the requester must identify what in the prior art is new, and that means what new non-cumulative technical teachings are in the prior art reference that were not previously considered in the prior examination of that patent. 37 CFR 1.510b1 requires that a specific statement identifying each substantial new question of patentability based on patents and printable publications be presented in the request. Merely proposing that over the prior art is not sufficient. The request must point to the new technical teaching that raises the question of patentability. The next topic I wanted to talk about relates to the service requirement. Both 37 CFR 1.510 and 37 CFR 1.550 require that parties include a certification that they filed a copy of the paper, either the request for reexam or any follow-on paper with the other party. This is only obviously in third-party requested reexams. If the request or follow-on paper does not include a certificate of service or does not provide a certificate of service which indicates service in the manner required by 37 CFR 1.248, then that paper may not be entered. For request, it is a hard and fast requirement, and the requester will not get a filing date awarded to that reexamination request without proper service. If for follow-on papers, a certificate of service is not filed or is filed which doesn't comply with the requirements under 1.248 for proper service, the office will give that party the opportunity to file a corrected paper with proper service. And this is subject to a few exceptions. One, that paper, the corrected paper must be filed within the time period for that party to respond. And two, that follow-on paper must show that the party actually served prior to the period for that response to expire. So in reissue application, we see several issues that practitioners and parties who are prosecuting reissue applications often fail to comply with. As Charles had indicated, each reissue must include a reissue oath declaration. And unlike 111A applications, in order to be forwarded for examination, the reissue application must be filed with a compliant reissue oath or declaration. So that reissue oath or declaration must include a statement that the applicant believes the patent to be wholly or partially inoperative or invalid by either a defective specification or drawing, or by the patentee claiming more or less than they had a right to claim in the patent. And this is going to be, and then also what is also required is a statement that identifies at least one error which is relied upon to support that reissue application. This is the basis for the reissue. If the error statement is asserting that the patent owner claimed less than they're entitled to claim, and they are presenting a broadening reissue, and they're attempting to broaden their patent, they must also identify a particular claim that they seek to broaden, and a single word, phrase, or expression in the specification or claim that they are broadening, and present how it renders the patent wholly or partially inoperative or invalid. Merely generically pointing to a statement that indicates a claim is being broadened is not sufficient. Next slide, please. Another area that we see issues with respect to reissue is the consent of assignee. If a patent is assigned, all assignees must provide written consent to that reissue. And the individual signing that consent of assignee must have either apparent or actual authority to sign on behalf of the assignees. The office takes the position that certain individuals with particular titles are presumed to have apparent authority to sign on behalf of the assignee. And this is generally an officer of the company or entity who is filing the reissue. And these would be the CEO, the president, the vice president, secretary, treasurer, those typical titles that we see as an officer of a company. It is important to note that in Europe, those titles may be different, but have the same effect. In addition, the individual who's signing the consent of assignee may demonstrate actual authority. And this happens when either the submission clearly sets forth that the person signing is authorized or empowered to act on behalf of the assignee, or that there's a prior submission in the file that had previously indicated that the signer was authorized to act on behalf of the assignee. And then finally, the consent of assignee may be signed by a patent practitioner of record who has already been established to be of record. If the patent is not assigned, the applicant should make an affirmative statement of non-assignment. And the office may interpret that the failure to do so means that the patent is assigned and hold that the reissue is defective for not having a consent of assignee. Next slide, please. Another problem that we continuously see with reissue application filings deals with continuing or divisional reissues, and specifically with the application data sheet, which is required for all 111 or reissue applications. For a reissue that is a continuing or divisional reissue, the ADS must demonstrate and must indicate that the reissue is both a continuation of the prior pending reissue that it seeks continuity from, and a reissue of the original patent. So this example that you can see on the screen right now is an example from the reissue application filing guide posted on the USPTO's website and identified in the Manual of Patent Examining Procedure. Here you can see that this reissue application is indicated as being a continuation of a prior reissue patent, prior issue application, and also a reissue of the underlying patent. Failure to indicate that a continuing reissue is both a continuing reissue and a reissue of the original patent on the ADS may lead to an incomplete or incorrect filing receipt. Another best practice recommendation for reissue applications deals with patent owner estoppel. It is important to note that 37 CFR 42.73 states that a patent owner may be precluded from seeking a claim, or is precluded from seeking a claim that is not patently distinct from a claim that is either canceled or previously held finally unpatentable in an AIA administrative trial. So if a claim of a patent was canceled or held finally unpatentable in an IPR or post-grant review trial proceeding, and the claim that is presented in the reissue is determined to be not patently distinct from that claim, the examiner may make an estoppel rejection separate from any prior art rejection. If during the prosecution of a reissue application, the applicant makes arguments as to patentability, the examiner may determine that those arguments are inconsistent with the final holding of an adverse judgment in the AA trial proceeding, and may determine that such arguments are thus estopped and therefore not find those arguments persuasive. As a recommendation, patent owner may wish to present arguments with their preliminary amendment explaining how the narrower claim presented in a reissue application after an IPR or PGR that resulted in a final written decision, how those narrower claims are not only free of prior art, but are patently distinct from those finally refused or canceled claims. Bauman type continuation or divisional applications is a non-provisional application that claims benefit under 35 U.S.C. 120 to a reissue application. If the applicant files a Bauman type application, oftentimes the underlying patent may be prior art against the claims in the Bauman application. Generally, a Bauman type continuation or divisional application is not filed deliberately, but is inadvertent. And patent owners can avoid the inadvertent filing of a Bauman type application by ensuring that, one, the type of application that is filed through the reissue application selection within Patent Center is a 251 application and not a non-provisional application under 111A. They should also ensure that they have complied with all the requirements of a reissue application, including a reissue oath or declaration, a consent of assignee, the original specification in double column format, and all other reissue application filing requirements. An applicant may attempt to convert an inadvertently filed Bauman type application in a continuing reissue by filing a petition and demonstrating that the application as filed has indicia of being a continuing reissue application. And examples of that indicia are included in MPP 1451. In both reexam and in reissue practice, amendments are practice is different than in 111 application. The key factor being, one, that all amendments in either a reissue or a reexam are always made in relation to the issued patent. Additions to the patent in a reissue or reexam are shown with underlining, and deletions are shown with single brackets. This is different than in 111 applications, where deletion is shown by strike through. New claims in both reexam and reissue are always made by underlining the claim in its entirety. In addition, in both reexam, claims numbering is always preserved. Actually, in both reexam and reissue, claim numbering are always preserved. So if the original patent had issued with claims 1 through 20, the next new claim must start at 21, irrespective of what happened in the underlying, with the original claims. Finally, in both ex parte reexam and in reissue applications, support for the amendments must be identified. Failure to identify support for an amendment in either a reissue application or a reexam proceeding may result in that amendment being held not compliant. Well, I think that's it for the best practices topics. So with that, I'm going to pass it on to Fenn Mathew, the acting director of the CRU, to discuss CRU updates. Thank you.
So as Steve mentioned, I'll be talking about a few CRU updates. We go to the next slide, please. So just as a roadmap, I'll be going over some relevant reexamination statistics, and then I'll be going into a discussion of a couple of pilot programs that the Central Reexamination Unit is currently involved in. And we'll talk about the recent OG notice that we'll be publishing in March that Charles had previously referenced, and then an update regarding the reexamination transmittal form. So beginning with our reexamination statistics, we're looking at reexamination filings over the last 5 years in this slide. So as you can see from the data, reexamination filings have been steadily increasing. However, we can see quarter by quarter in the past year, these reexamination filings have seen a significant uptick. Looking at the difference between Q1 of 2026, which is the bar all the way on the right, we see the significant uptick in filings. This graph also demonstrates filings by discipline. The Central Reexamination Unit examines reexams via different disciplines. So we have data on reexams that were filed for the chemical discipline, the electrical and business methods discipline, mechanical discipline, and as well as designs. As we can see from the data, there have been increases across all of the disciplines, but most recently we've seen the most significant increase within the electrical disciplines. So this slide shows the timeliness of determination of substantial new question of patentability, or SNQ. So under 35 U.S.C. 303, once a reexamination request has been made, a determination on whether to proceed must be made within 3 months of filing. So here we see the red line at the top represents the statutory deadline required to mail a determination on the reexam request. As you can see with the lower line, the Central Reexamination Unit, or CRU, has been doing a fantastic job in terms of timeliness. Despite the increase in filings, the CRU has been able to maintain relatively steady timeliness in making their re-exam determinations. In this slide, we're seeing the average time to notice of intent to issue an ex parte re-examination certificate. As Charles had mentioned earlier, re-examination culminates in the filing of a NERC, or Notice of Intent to Issue Ex Parte Re-examination Certificate. So here we have two lines. The top line represents the average months until a NERC is filed for all re-examination requests. So once again, we see, due to the great work of the CRU, that they have maintained pretty steadily despite an uptick in filings. That approximately 16-month pendency includes all re-exams, irrespective of whether there is a notice of appeal filed in them. We see on the lower line that if no notice of appeal is filed in the re-exam, that the pendency drops down to about 12 months until NERC. Once again, representative of the great work being done by the CRU. So the overall average months to NERC, including applications that go to appeal, include re-exams that not only go to the PTAB, but also to the Federal Circuit. So the lack of a notice of appeal significantly shrinks the overall pendency for a NERC. And just by way of scale, approximately 75% of all re-exam requests do not contain a notice of appeal. So while the CRU has done a great job in maintaining their timeliness, CRU is also actively aware that there's a significant uptick in re-exam filings, as evidenced by the prior slide. So if we go to the next slide, CRU has taken some active steps through pilots to explore ways to expand CRU's examination capacity and to improve efficiency, to more effectively meet stakeholders' needs. So one of the pilots that have been started by the CRU is a re-examination conferencing panel pilot. So each office action during a re-examination proceeding is subject to a conference, and this includes examiner answers, every single proceeding within the re-examination process. So under standard practice, panels would consist of 3 or more members. Usually the lead patent re-examination specialist who is in charge of the proceeding, a supervisory patent re-examination specialist, and either another patent re-examination specialist or supervisory patent re-examination specialist. In August of last year, the USPTO established a pilot to modify the panel review process. So during this process, the panel would include the patent re-examination specialist in charge of the proceeding, as well as 1 supervisory patent re-examination specialist. So we're shrinking the panel from 3 or more members down to 2 members. The modification is expected to allow CRU examiners to focus on assigned re-examination proceedings in lieu of participating in review conferences, thereby creating greater examination capacity and improving efficiency. In that same vein, CRU also has engaged in a production pilot. So due to re-examinations, supplemental examinations, and reissues being handled with special dispatch, the CRU has historically met their requirements by focusing on timeliness. However, in July of last year, the CRU launched a production pilot to add a production credit system for patent re-examination specialists. This production credit system was based off of the patent examiner production system, a modified version of the patent examiner production system. The addition of the production element is to help expand CRU's examination capacity and improve efficiency to more effectively meet stakeholder needs in the face of these increased re-exam filings. During the pilot period, CRU issued 23% more first actions on the merits and orders than the same time period preceding the pilot, and this occurred despite a 32% reduction in staff. This production credit system is designed to increase capacity while continuing to maintain the high quality and timeliness associated with the CRU. Our next slide deals with the upcoming OG notice on filing of anonymous ex parte re-examination requests directed to previously challenged patents. So this notice will publish in the official Gazette on March 3rd, 2026. So the USPTO receives ex parte re-examination requests under 35 U.S.C. 302 that are directed to patent claims that have also been challenged in IPRs or PGRs, it's inter partes or post-grant reviews. A real party in interest may file a re-examination request and remain anonymous when filing that re-examination request. And they can do that by utilizing the services of a registered practitioner. In those instances, the registered practitioner that submits the request for the re-examination on behalf of that anonymous party is certifying the fact that the estoppel provisions of 35 U.S.C. 315 and 325 do not prohibit the requester from filing the request. This allows the requester to maintain their anonymous identity while also certifying that the obligation, while also certifying that the estoppel provisions do not prohibit them from filing the request. However, guidance has been updated that if at least one claim for the patent requested for re-examination was previously challenged in an inter partes or post-grant review proceeding that resulted in any final written decision on that claim, the anonymous requester should provide an affirmative statement in the request that the real party in interest is not the petitioner of the prior IPR and or PGR proceeding, or the real party in interest or privy of the petitioner. Additionally, the affirmative statement should identify the IPR or PGR proceedings, as well as the petitioner and any real parties in interest listed under 35 U.S.C. 312 and or 322, or otherwise found in the record of the identified proceedings. This affirmative statement will provide USPTO personnel additional assurances that third-party requesters' certification under 37 CFR 1.510b6 is accurate and will assist in determining whether an anonymous request for an ex parte re-examination is entitled to a filing date. So the final update that we wanted to bring to your attention was the updated re-examination transmittal form. So in November of 2025, the USPTO updated its re-examination transmittal form to make clear when the re-examination requester opts to remain anonymous, and that no requester should be identified in box 2A. This update to the form was made because practitioners were listing themselves instead of the client as requesters on the previous iteration of the PTO SB 57. So if we go to the next slide, we can see the updated re-examination transmittal form. So here on the form, at the top half of the form, we see very clearly that there are separate boxes in order to identify whether the requester is anonymous or if they wish to be identified. if the requester would like to be anonymous, they should check the box 2A. 2B is specifically for if the requester's identity is to be publicized. Box 2B should not be used to list a third party's legal representative if the representative is not a requester. Looking at the bottom half of the form, box 17 is where the requester's attorney's name and correspondence address would go. So this should clarify and prevent any mistakes with respect to placement of an attorney's name on the form. So in terms of takeaways, we hope you received out of this presentation is that CRU has seen a significant increase in their re-exam filings, especially over the last year. However, CRU has also taken proactive steps to increase examination capacity and efficiency while continuing their high-quality examination and timeliness. And finally, we've shared some best practices that can help ensure more efficient prosecution of re-examinations and reissue applications. And with that, I will kick it back to Sean.
All right, I want to first say thank you to Charles, Fenn, and Stephen for a wonderful and very informative presentation. We did take questions in advance. I'm sorry we're a little tight on time, so I'm going to try to see if I can get at least some of the questions in before we run completely out of time. So there were questions taken in advance, and you can still submit them to USPTO Hour at uspto.gov. Some of the questions in advance, let's get started with those first. Can 35 USC 101 or 112 issues be raised in a re-examination? What about a supplemental examination request?
All right, thank you, Sean, and I can take that one. So generally, patentability issues relating to 101 and 112 are not considered during reexamination. There is an exception in those cases where the patent owner amends the claims during reexam, then the examiner may address issues under 112 with regards to those amendments. For supplemental examinations, the patent owner may address issues under 101 or 112 in the request for supplemental examination by identifying in the request the discussion of the 101 or 112 issues as an item of information in that request. Also, the examiner, even if the 101 or 112 issues are not raised in the supplemental examination request, the examiner can consider those issues as part of a re-examination proceeding that is ordered based on the supplemental examination request.
All right, thank you for that, Charles. I know we're just a little bit over time. I do want to try to sneak, excuse me, sneak a few questions in here. Let me see. Have you guys noticed that the distribution of re-exam filings between chemical, electrical, and mechanical has stayed steady? There seems to be an uptick, excuse me, in the past quarter or so of chemical filings.
So I can take that one, Sean.
Okay.
So there has been a significant uptick in ex parte re-examination requests filing as a whole over the last 6 months. However, what we have seen is that electrical filings are most responsible for this uptick. There have been an increase in chemical filings, however, electrical filings have the most significant uptick.
Okay. Thank you for that. Let me see. You guys mentioned streamline requests earlier. What percentage of re-exams are streamline requests?
Steve, I think you're on mute.
Apologize for that. I can handle that question. So over the last 5 years or so, we've seen on average about a 25% rate of filing of supplemental examination requests. They obviously vary from year to year, but on average about 25%.
Okay. Thank you for that. I know we're tight on time here. We're a little bit over. I'm just trying to sneak a few questions in here. Um, there's a question here you guys mentioned in your presentation, special dispatch. Maybe you can expand on what that means.
Sure, I can take that one.
Okay.
So special dispatch is recited in 35 USC 305. And this is a requirement that relates to the office expeditiously handling re-exams. There is a 3-month time period, a statutory deadline for making a determination on the SNQ. But as Fenn mentioned, as he discussed in one of the slides, the CRU is currently making those determinations well within 3 months. I think on average, we're right around 2 months. The other part of special dispatch is on the patent owner side. So the time periods for a patent owner response are typically shorter than, for example, 111A applications. Patent owners have to respond within 2 months instead of the 3 months that's given for 111As, as well as the extension of times are a little bit different as well. For during re-exams, patent owners are limited to a 1 month extension of time, and they must show cause. And as Fenn also discussed as part of his updates, the CRU is meeting this special dispatch requirement. On average, our pendency is around 12 months if no appeal is filed, and 16 months, including all re-exams that include re-exams where an appeal is filed.
Okay. Sounds good. Thank you for that, Charles. I'll try to sneak one more in here, recognizing, want to be mindful of folks' time. Um, for service, there was service mentioned in the presentation for third-party service. What qualifies as service? For example, is email acceptable?
I'll take that, Sean. So right now, under 37 CFR 1.248, which governs service, the types of service by transmission is limited to first class mail, that is US first class mail. There can also be complying with 1.248 can be personal service, serving the individual, the patent owner at their place of address or party at their place of address. However, for service by transmission, it is limited to first class mail, and thus email, facsimile, and other manners of service are not in okay under 1.248.
Okay. Thank you for that. I'm sorry, unfortunately, we are just a little bit over time here. We ran out of time, but I want to say a huge thank you again to Charles, Ben, and Stephen for a great presentation. Uh, Humoring me a bit and sneaking in a few of the questions that have come in today. For those of you who do still have questions, please feel free to send those to USPTO Hour at uspto.gov, and we'll make sure they get to our panelists. Also, as a heads up, you will receive a survey within the next week or so to the email address in which you registered for today's program. We really would appreciate it if you take the time to fill it out. We use it to take your feedback and understand how to better meet your needs and improve this program and others that we provide here at the USPTO. So with that, I want to say a huge thank you again to all of our panelists. Thank you to you guys for taking time out of your day for attending, and hopefully we'll see you somewhere soon. Have a great day and the rest of the week.